explain what the justices were arguing or what their questions were yesterday in the Supreme Court.
Sure. Well, thanks for having me back, Amy and Juan. And the conservative justices, 4 of them, and in many respects, Anthony Kennedy as a 5th, were concerned about really 2 things. Number one, does the Voting Rights Act cover the right states? So is Section 5 still targeted at those places where discrimination is most prevalent? And then number 2, the second thing that they were concerned about is there a replacement for Section 5? Because they view Section 5 in many cases as an infringement on state sovereignty. So they were wondering, do other provisions of the Voting Rights Act, such as Section 2, could it be an adequate replacement? And the people that were defending the Voting Rights Act, both Solicitor General Donald Verrilli and Debo Adegbile of the NAACP Legal Defense Fund, said that yes, discrimination is still targeted in those states covered by Section 5, and there is no replacement for Section 5. It's the only section of the Voting Rights Act that puts the burden of proof on the discriminators themselves to have to prove that a voting change is not discriminatory. So it's the only preemptive weapon in federal law to stop discriminatory voting changes, and that's what makes it so powerful.
And Ari, on the exchange, it was not a direct exchange between Sonia Sotomayor and Justice Scalia. Could you talk about that? Because I think it's the first time that Justice Sotomayor comes out clearly in a court hearing so strongly opposed to one of her fellow justices.
Well, Scalia made the outrageous statement that the Voting Rights Act is a perpetuation of racial entitlement, and that's why Congress has supported it so overwhelmingly. And Scalia basically said that the overwhelming congressional support for the Voting Rights Act means it must be unconstitutional. And Sotomayor basically said discrimination is discrimination. It's ongoing today. This is not racial entitlement. This is about a basic fundamental right that for so many years America ignored. And she said to Shelby County, the county that's bringing the state, you don't have the standing to bring this challenge because as recently as 2008, you were found by the Justice Department to be discriminating on the basis of race, doing a voting change that eliminated one of the only black districts in a city in the county. So Sotomayor basically said there was no basis to bring this challenge to the Voting Rights Act itself.
I want to turn to a clip going back in history from a documentary that recently featured King. It's called A Filmed Record, Montgomery to Memphis. This is President Lyndon Johnson speaking just as he is signing the Voting Rights Act in 1965. Over his shoulder is Dr. Martin Luther King, who speaks next. First, President Johnson.
Today is a triumph for freedom as huge as any victory that's ever been won on any battlefield. This law covers many pages, but the heart of the act is plain. Wherever, by clear and objective standards, states and counties are using regulations or laws or tests to deny the right to vote, then they will be struck down. If it is clear that state officials still intend to discriminate, then federal examiners will be set in to register all eligible voters. This good Congress, the 89th Congress, acted swiftly in passing this act. And I intend to act with equal dispatch in enforcing this act.
I think the greatest victory of this period was not in terms of an external factor or an external development, but it was something internal. The real victory was what this period did to the psyche of the black man. The greatness of this period was that we armed ourselves with dignity and self-respect. Greatness of this period was that we straightened our backs up. And a man can't ride your back unless it's bent.
That was Dr. Martin Luther King, and before him, President Johnson from King, a filmed record, Montgomery to Memphis, the day President Johnson signed the Voting Rights Act. Ari Berman, where does it go from here as we hear the significance of this moment when this was signed in 1965?
Well, it's been such a transformative law. It's often been described as the most consequential law passed in the 20th century and really the high watermark of the civil rights movement. And Section 5 is the heart and soul of the Voting Rights Act. So if the Supreme Court was to get rid of Section 5 or to significantly narrow it, and we would know this in June when a decision comes down, there really is no substitute for it, and it would be a very devastating setback for voting rights, not just in the places where Section 5 is covered, but there's a thinking that if Section 5 goes, conservatives are going to start challenging those other provisions of the Voting Rights Act, like Section 2, which applies nationwide. The court has already limited Section 2 in many respects. So this would kind of be like the Citizens United decision for voting rights. It would open the floodgates to more voter suppression laws, more legal challenges, and it would make it difficult to enforce the voting rights laws that are on the books in addition to Section 5. And so there really is no substitute, and it would be one of the most radical and consequential decisions made by the court in a very long time.